the things that we really think would really be important to this matter is that we have a clear definition of what is recreation, so that our business owners can make sure that what they're doing and have that clearly in their business plan. We want to make sure that there's consistency when there is a definition, how it's applied, and consistency is really important.
One item of concern that I have with the Department of Revenue is in businesses that are delinquent in paying their due sales tax that they've collected from customers back to the state, so it can be allocated to the state and other taxing jurisdictions. First of all, we do have a good relationship with the City of Mexico and the DOR as far as being able to communicate back and forth. There is one area that we need to strengthen, and that is how we go about collecting delinquent taxes. Some of the examples that we have run into is we will have someone that runs a business, they have become delinquent on making their sales tax payments to the state. We get a notification from the state that that has happened. We basically do the policing on that, so we will contact that business or write them a letter saying they have X number of days to get that sales tax caught up. Otherwise, we would need to possibly shut down that business, which is not good for them, nor is it, it's kind of a black eye for the community of the City of Mexico to have to shut down a business for that reason.
We continue to improve what we're doing with the Department of Revenue. And I very much appreciate the fact that this committee is trying to find out more. And Senator, we would welcome you for a tour and to see, not just on the basis of the experience of one or two data points, but looking at the whole, at the overall experience of taxpayers in the state of Missouri and the job that the department has to do, whether it be collecting it. It's rare that we get the complaint that we're being too hard on business, not hard enough on business. We do sometimes hear the complaint that we're too insistent on payment of taxes, but certainly hearing today the complaint that we're too generous in allowing payment plans. That's not usually what we hear, but there is a balance we have to strike. Certainly when we go about the process of deciding should this business that has collected tax from its customers and not remitted that tax to the state of Missouri for distribution to the cities, should they be allowed to stay in business to pay off that tax debt or not? And that's a difficult decision. The money is owed. The money has been collected from the individuals who are purchasing the services. How long should that business have? They're already delinquent. That's not an easy question to answer. We certainly try to be consistent in our answer, but I also acknowledge there may be individual instances where one answer may have been slightly different than another. We try to do the best we can to collect all the tax due under the law and not a penny more.
How did that move from fitness centers to gymnastic studios or dance studios and competitive cheer?
A lot of that was driven by taxpayers. For example, you've got a gym that has Zumba classes and jazzercise classes. It's a gym, so it clearly is taxable because that's what the statute and the Supreme Court said. So the gym, when we're in there auditing the gym and we say your jazzercise classes are taxable because that's what the law says, what about the jazzercise studio just down the street? Isn't that recreation too? I mean, we internally, we could not make a distinction between a jazzercise class and a gym and a jazzercise class and a jazzercise studio. So yes, we.
What about a dance studio?
Same issue. There's gyms in the city of Columbia that have dance type classes as well.
Yeah, but you said, clear me wrong, you said that if it's in the gym, then that's taxable because it's a gym is a place of amusement, according to the Supreme Court ruling. But if it's outside and you were a trainer that gave personal training, but you were not associated with that gym, then it wasn't taxable because that was a lesson. So we're talking about a dance studio that's not in the gym. We're talking about a dance studio that is individual entity.
Senator, I don't think I was clear, so I apologize. The difference is not that it's in a gym and the case of the trainer that's not in a gym. The difference is who's getting the money. Is it the place of recreation? If it's the place of recreation, the statute says it's taxable. If it's not the place of recreation, so if jazzercise in a gym is recreation, and jazzercise in a jazzercise studio is recreation, is there a place of recreation? Yes, the jazzercise studio. Is the jazzercise studio getting paid money? Yes, they are. So they're just like the gym teaching jazzercise. Now, if I had a big open space that I rented out to people, and somebody came in and used it to teach a jazzercise class, would that be taxable? Maybe not. Because if that big open space is a place of amusement, maybe the place of amusement isn't getting the fee. So that's the difference.